Let's review your answers. In scenario 1, the person who has the medical need is the spouse of the employee. That is a qualifying family member. The employee's wife has an extreme case of morning sickness and has been off work 3 days in 1 week, 2 days in a subsequent week, and 2 days in the following month. The leave would be covered under FMLA and the employee would be entitled to intermittent leave. In scenario 2, the person who has the medical need is the stepbrother of the employee who's 22 years old. Is this a qualifying family member? In this instance, yes. FMLA is extended to a family member who is categorized as step or half. And if the person is over 18 but incapable of taking care of themselves, whether it's because of mental or physical disability, they will qualify. In scenario 3, the person who has the medical need is the employee herself. At the end of the day, she started getting heart palpitations at work and went to the emergency room for a few hours and was off work the next 2 days. She was never admitted, so this does not qualify as an overnight stay. Also, the law states that the employee must stay overnight in the hospital for a substantial period of time, which currently is defined as at least 8 hours. Therefore, she is not eligible for FMLA. As you can see, FMLA coverage is based on specific reasons. That's why it's important to understand the terms serious health condition and family member to see if your situation is covered. Now, as a manager, your responsibilities are to understand and comply with FMLA, related state laws, and leave policies. Understand when an employee's absence could fall under FMLA and proactively work with the employee to respond to his or her leave request. And plan for coverage when the employee is out of the office. In your resource folder, you'll find more information on FMLA. Because small offices may not have an HR department, I want to bring up some things you should consider. Know what the minimum wage is that you must pay your employees. Keep in mind there are federal, state legislature, and city regulations and local ordinances. In your resource folder, we've provided you with the link to the Department of Labor minimum wage information by state. Find out if there's a minimum exempt salary for individuals based on their profession. Overtime is not automatically based on when an employee works more than 40 hours in a week. In some states and cities, you must pay overtime if an employee exceeds a certain number of hours in a day. Keep your payroll records for a minimum of 4 years, and you must post the Office of Wage Standards wage notices in a language spoken by at least 5% of the workforce. Lastly, keep in mind that when you're interviewing prospective employees, you're prohibited from asking about citizenship, marital status, disabilities, and sexual orientation, and other protected classes. More accurately, the laws prohibit an employer from refusing to offer employment to an applicant based on the applicant's citizenship, marital status, disability, sexual orientation, or any other protected class under federal, state, or local law. So, we reviewed 3 basic HR law categories that you should know: preventing workplace discrimination, fair pay, and family and medical leave. Keep in mind, this is just an overview of some of the laws that govern these categories. Not only must you comply with federal and state laws, you should also understand local employment laws that govern your area. Now more than ever, managers need to familiarize themselves with these employment laws to ensure you act within the law. It's not enough to follow company policies. It's equally important to make sure you fulfill your duty to protect the resources of the company you work for, which include avoiding liability. But the best piece of advice we can give you is work with HR. Both of you have a vested interest in ensuring your company is successful. Working together, you'll gain a better overall understanding of HR and become more efficient in tactical human resources functions.